In the name of the Father, the Son, and the Holy Spirit. Amen. Heavenly Father, we give you thanks and praise for all of your wonderful gifts. We especially thank you for the gift of vocations, of marriage, of family. Lord, we ask you to enlighten our hearts and our minds and our souls this evening so that we may better our discipleship in your name. We ask this through Christ our Lord. Amen. Father, Son, and Holy Spirit. Amen. There are a lot of ways in which we can approach the topic of annulments. And I want to approach them in a number of different ways, but in general, we can start with the notion of our faith and doctrine. We can start with a theological understanding, a spiritual understanding, and finally, a canonical understanding. And believe it or not, all of those things go together. A lot of times when I'm at the Tribunal working, we get phone calls from various people inquiring about annulments or wanting to just ask questions about annulments. They really seem to focus primarily on that canon law aspect of the practicalities, how this is done, or what does this mean. But it really only makes sense if we understand it from the doctrinal, theological, spiritual perspective first. So we always begin with the notion of what is marriage in the first place. Now we're going to have in the series, I know that Father Hathaway is going to give a whole talk on what marriage is and bring everything together and wrap it together. But let me at least say that marriage is a union of a man and a woman coming together in a commitment of partnership for the whole of life that is open to life and is exclusive to themselves, meaning there's not going to be relationships outside the marriage. That's what they are intending. That's what we see in nature. It's what we see before Jesus coming to the world, before the formulations that we see in the Old Testament about marriage. It's something that human persons can naturally intuit, and we see in different societies throughout human history that is lived out in different places and different cultures. We know that sometimes that gets skewed, but that's just because of human sin, and original sin in particular. And so the vision gets skewed, but primarily we start with that vision that we see God communicating to us from natural law. And then there's the doctrinal understanding, which illuminates that a little bit more. Not only do we see it played out in the Old Testament or in the life of the prophets, especially those that will describe God's relationship to his people in terms of a matrimonial covenant. So the language moves from sort of a natural bond to this idea of a covenant, a real joining together of an understanding or a contract of how this relationship is defined. It's not just what we're consenting to, but also what we expect of one another in our roles in this particular marriage. And then Jesus comes along in the New Testament, Gospel of Matthew and Gospel of Mark, and really highlights for us this notion of what God intended from the beginning when he speaks about the permanency of marriage and elevates it beyond a natural bond, but for those who are baptized becomes a sacramental union, another sacrament in the life of the church, so that it also communicates grace, not just a union of persons, but salvific grace and sanctifying grace that enables this couple and tries to empower them to live out the commitment that they are making. And then that is why Jesus gives us that very understandable exhortation that is so powerful that we also use it as part of the marriage rite itself within the church, that what God has joined, no man must separate. So where does that leave us in terms of what we know is a real and true reality in the life of the world, in the life of human persons, and in the life of the church? Because we know, as Pope Francis has stated, that sometimes love fails. Sometimes love, that emotion of love, isn't enough to sustain that marital union. We know that there are a lot of studies, and we've heard a lot of studies about causes and underlining causes that lead to the breakdown of marriage. We know that the church goes through a great deal of effort in trying to create programs such as the pre-Canon program or the marriage preparation programs to try to address some of the things that we see, and primarily where the church is getting some of that from its pastoral experiences comes from the offices like mine, the office of the tribunal, where we are seeing and going back to the very beginning and the root and trying to understand from the beginning what was getting in the way. Because at the end of the day, annulments are different than that civil idea of divorce. A divorce is a couple reaching a point in their relationship and recognizing that there's something irreconcilable here. Some things have gotten to a point where there is such brokenness in a relationship because of personal and original sin that we can't continue. Or one person has abandoned the other. Why? Because of sin again. That sin becomes the root in some way, shape, or form of that marital breakdown. And so when the church is looking at annulments, it primarily does not look at the divorce aspect, because we understand what Jesus is saying in his exhortation that marriage is a lifelong, till death do us part union. That when a marriage comes together and it is consummated, it is sacramental, that no human power on earth can dissolve it, even the parties themselves. The church, therefore, has given us through the invitation of Christ the idea of the possibility of asking another question in this circumstance for the couple. Was it possible that what we thought was a valid sacramental marriage was actually, in fact, not valid? And if it was not valid, then it was not this permanent union, and both parties are then free to enter into a sacramental bond or a union of marriage with another person within the life of the church. And that becomes the core question that the tribunal is trying to investigate. There are a lot of ways in which we know that documentary or just on the surface, the church would say, well, this isn't invalid. So we would start with things that probably each of us who are well catechized know regarding marriage. That if a Catholic gets married outside the church without proper dispensation, they get married to justice of the peace to another person, or maybe to Catholics, that off the top we say, okay, that's not valid. We know that because they didn't have, as all sacraments are supposed to have, proper matter and form. And so if that marriage breaks down, there's not going to be a big investigation, because all they have to do is show the priest and the tribunal, here's the marriage certificate, we never got married in the church, so we were never really validly married. There was a union, sometimes there are children, there was a relationship, all that stuff was real. But in terms of the validity of the marriage bond, we would look at that and say there was something from the beginning, and in this case, a lack of form that kept that marriage bond from coming together and being a permanent bond of marriage. The other form that we see and that most people want to talk about, however, is the formal case. And that's the one where we get in and we investigate. We look at our faith and we understand what marriage is in that sacramental bond. One of the things that we have to ask ourselves, how does one enter into that sacramental bond? How does it come about? Well, all of us know we've been to weddings. And what happens at a wedding? The couples come forward, they present themselves, and then they do something in front of the priest who is representing the church and witnessing this union on behalf of the church. And what do? They literally speak what? Their marriage vows, right? They make that commitment. In other words, they're publicly saying to God and to the congregation and to one another, I am consenting to marry you. And this is what I mean by that consent. That it is a permanent, lifelong union, that I am open to children and intend children if that is possible, that I'm not going to be with somebody who's not my spouse, and that I am here for the good of this union and to be a real partner. Well, given what we know about human persons, we know that there can be difficulties in making consent. And Jesus is the first to allude that there might be an issue here. Because when Peter talks to him about the permanency of marriage, the first thing he says to him is, who in the world can live that out? Right? And that, I think, is a natural response. When we look at the difficulty of any vocation, but in particular a married vocation where two imperfect persons are trying to live out a harmonious union. Right? There's going to be imperfection there, and sometimes there's grave imperfection. Grave imperfection. And here I'm speaking of addictions, abuses, things of that nature. And so you have people coming together, and so this is what St. Peter is thinking about when he comes back to Jesus and says, who in the world can live this out? And Jesus' immediate response is, those to whom I call will be able to live it out. But then he follows up by saying, unless the marriage was unlawful in the first place. Wait, what does that mean? That means he's getting at this idea that there's a possibility that if the marriage was not valid, then there's a possibility of remarriage in the church later on. So who are those who should seek an annulment? It's anybody who is seeking, who is previously married, divorced, and seeking the possibility of marrying in the church. That could be a non-Catholic, that could be a Catholic. Right? So one of the myths that I run into pastorally speaking, not just in the tribunal, but when I'm working with couples, is that I'll get a Catholic and a non-Catholic, and the non-Catholic will have been married before and divorced, and I have to say to that person, we need to see about an annulment, see if you're free to marry before we can move forward. And the Catholic is usually the one that's the most surprised. Because they say, well, but this person's not Catholic. Why do they need one? Because we recognized when they stood there and they made that promise and they made that consent that they were validly married. We wouldn't have said during that married life, that, hey, we don't recognize that marriage. That wouldn't have been appropriate for us to do because two free people stood forward, made that consent, and marriage came into being. So that's one myth that we should work on dispelling within the church. And we have family members, whatever, we should be willing to make sure that we understand that we recognize all valid marriages, whether they're Catholic or not. So when they come forward, we have to say, okay, we have to do this. And then what is it that we're investigating primarily is the marital consent itself. So what we're looking at is saying, what was possibly in the way of this person making a free act of the will to consent validly to marriage? If it's an invalid consent, then there has to be some reason, some explanation there. The church's starting point in a marriage investigation is that the marriage is valid. We make sure that we tell our petitioners who are coming to us to know that we're starting with the presumption that your marriage that we're investigating was valid. And what we're trying to do is see if there's enough evidence to come forward to overturn that presumption. And so what the judge is looking for in the case is what we call moral certitude, to be able to say he is willing to stand in front of God in terms of his eternal salvation and say, knowing everything that he knows right now about this marriage, about the marital consent, that any other reasonable person would look at all of this and come to the same or similar conclusion. So every sentence always begins with, in the name of God, to remind the judge that he must be willing to stand before the face of God with this decision. So there are a number of ways in which we're looking at that marital consent. Well, it's not, the investigation is not too dissimilar from understanding what it takes to commit grave sin. Right? So most of us would probably be able to list off what it takes to commit grave sin. We have to have full knowledge of the will. We have to have true freedom, and the matter must be grave itself. Right? Those three things must be in place. And then we have to understand what's going on inside in terms of all those psychological factors, whether there was pressure, things of that nature. And so the investigation, it's a very good parallel and a very good analogy to say that the investigation for marital consent follows some of those lines, because what we're trying to do is get inside what was going on in a particular person when they were standing there making that choice. So there are a couple of things that we look at. We look at the freedom of the parties in terms of their will. Was there any internal pressure? Was there any outside force or of threat or grave fear? We want to know if the person was lying in some way. Were they making a promise, but they weren't really telling the truth? They were saying to this other person or to the entire congregation or in front of a priest or another minister or whomever that they were intending to be faithful, that they were intending a permanent union, that they were intending children, but never really meant it. They were withholding that in some way. They were lying there. Were there other factors, like somebody deceiving another? Because they knew if Judy knows about this and I tell her, she will never agree to marry me. And I know that I got to keep it hidden from her as long as I can so she never leaves. And so when they enter into marriage, then later on they find out and Judy leaves, John understands that the only thing that was keeping her there was the lie. Well, poor Judy was deceived into entering into that union. So she wasn't making a full informed act of the will. That's why those cases can be a little bit difficult, because we have to get inside the acting person. What was really going on? We will ask questions about what was going on in the marriage, but only insofar as to reflect back to that moment where the two were promising to one another this gift of marriage. And so what we have to understand is that, and what I've come to understand and naturally intuit, I think just as a human person, not just as a priest, is that when we do that investigation, we have to do it with a great sense of sensitivity, because we're often talking about some of the most painful things in another human person's life. Some of the most painful things. Now, we've been talking about this in a sense of, where does a church do this? Why does a church allow somebody to come forward and contest the marriage? And then sort of what the nature of the investigation is about. But we've been doing it in a sense from the perspective of a party petitioning. So the person who seeks out the annulment, we usually call the petitioner, because they're petitioning the tribunal and asking for this consideration. Every tribunal, if somebody is coming forward and they're divorced and they're seeking this clarification, the church is primarily always going to at least consider the petition. And the reason for that is that if it turns out that somebody's consent was invalid, then it means they are free to marry and they have a right to get married in the church. So we have to make sure that we honor all of those rights. So essentially what the church is saying, every person has a right to have their status clarified. And that's what the annulment process is trying to do. It's not trying to grant affirmative decisions. It's trying to find out what the truth is. And so in doing this investigation, like I said, we start with the presumption that it's valid until there has been sufficient proof brought forward in all of these categories to be able to say that presumption is overturned. It's not always the case that might happen. Another person is involved in this investigation and has the right to participate. And that's the other spouse, the former spouse. He or she has a right to know and to participate in every single way a petitioner has to participate. So what are those ways that a petitioner and the other party, who's often called the respondent, have to participate? The first is that they can give testimony. They can say, and have the right to say, here's my perspective of what happened. Here's what I believe to be the truth about this situation. They also have the right to name witnesses, to be able to say, and I also have 3 other people that can corroborate what I'm saying, and bring those forward and say, I've got my mother, my brother, and my best friend who was at the wedding, and maybe my best man, or maybe the maid of honor. And they're going to be able to basically say what I'm showing you, what's going on here. The church always takes seriously that participation of the respondent, because with both testimonies, we're much more likely to get at the heart of what is really true is going on. So we know, like we could, if many who have children or have been a part of arguments of their family members, you know that there's always 2 sides to every argument or every disagreement, every breakdown. There's always 2 sides. But when you hear both sides, you're much more likely to come to a sense of what is true here, what is going on. So we always reach out and have to give an opportunity to respect the right of the other party. We write to them, we ask them for their participation, and they can write back to us and say, I'm not interested, don't ever contact me again. They can write back and say, I'm interested in just giving my testimony, I really don't care either way. Or they come back and say, no, I really believe that this marriage was valid, and I don't wish ill will of my former spouse, but I really feel that this is a valid marriage, and I've been living my life as if I'm still married. In other words, I'm not seeking to date or to get married again because I think this is valid. And so they have all the rights to participate. We've heard a lot in the news because of the Synod of Bishops, and also because of, on September 8th, the motu proprio from Pope Francis speaking about marriages. I still kind of chuckle at the headline that says, Pope Francis simplified the marriage annulment process. The reason why I chuckle is because it's actually more complicated than ever before in terms from our perspective, what we have to do. And there's a lot of reasons for that are beyond the scope of this topic, but in terms of what he's expecting and what he wants out of the tribunals and some of the other things that he's asking us to do, which are all fine and good, it's anything but simple. In fact, a lot of canon lawyers around the world are going, okay, it's going to take time we know this comes to effect on December 8th, but none of us know exactly, fully, completely what any of this means yet. And I was at a conference a month ago, and one of the priests who worked on the council to give us all the new norms literally said to all these canon lawyers in the United States, there are 500 of us, it'll probably take 3 or 4 years to figure it all out because it's that complicated. It's not as simple as, it wasn't a simplification. He certainly cut out certain things at the end, but up front there's a lot more work involved. And so one of the things that I hear a lot of is, one, that everything's going to happen really quickly now. And I've heard all kinds of things about time. 45 days, that's the big number I keep hearing. Well, first of all, in the Pope's motu proprio, the legislation, there's nothing in there about 45 days. It's more like that when you put all the numbers together and all the processes together, it's at earliest 160 days to do the shorter process. It's also not very likely when you understand what would go into using the quote shorter process, how often or if it would be beyond a rare occurrence that we would actually legally be able to do that within the life of the church. And part of that has to do with the idea that the other party has to also agree to everything that's being said and presented in the petition of the other party. And my experience is that that almost never happens. So I don't know how often we'll use that abbreviated process. The other thing that the Holy Father has done, there's probably two things that have been most helpful, are that he's expanded the way in which a local tribunal can claim competency or jurisdiction over a case. The reason why that's important for our diocese is that we have many people who are married in Latin America and other places, third world countries, and we have up until December 8th of this year, no jurisdiction to claim the ability to hear that case. And many of those cases, even though there's been a petition, literally nothing has happened for 2 or 3 years. And as much as we write and as much as we reach out, we're not able to get any information on what's going on. So starting December 8th, we will then, in this diocese, if somebody lives here, we will be able to hear that case. We'll be able to hear that case. The other thing is there's no longer going to be a need for a conforming affirmative decision. What does that mean? Well, in the process that we have now, after the tribunal hears it locally, in the local diocese, or in the diocese in which the case is first heard, then if the judge grants an affirmative decision for the person to be considered free to marry, it has to go to another tribunal who reviews everything. And on a panel of 3 judges says that the first tribunal used the right grounds, the right law, upheld everybody's rights, and applied the facts to the law correctly. If they don't feel that they've done that, then they might reopen the case and they might grant a negative. So a person would only be free after they hear, well, the Holy Father said, we're going to get rid of that need. Certainly, either party always has the option to appeal to that court. So if there's an affirmative decision and the respondent is not happy with that, they can appeal the decision and it goes to second instance. Or they can appeal it and it goes to Rome. If the court gives a negative decision and the petitioner or the respondent want an affirmative decision and they want it to keep going, they can appeal that and take it to the next second instance or to Rome. So it doesn't end with the court of first instance. It just means that it's not automatically appealed. The need to have a second affirmative decision has been taken away. And that will help in terms of, in our own diocese, it usually takes another 6 months or so to hear back from the Diocese of Richmond after we've given an affirmative decision, when we've been able to do it. So now that time would be taken off, but it doesn't really change the process that we currently use in that first hearing. We still have to be able to do all those things: take testimony, collect testimony from witnesses, allow the rights of the other party to be respected, allow them time to participate in all the ways in which they're allowed to participate. So it doesn't mean that we'll be able to automatically flip a switch on December 8th and start hearing cases zoom, 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 zoom. It'll pretty much go along as we're used to and accustomed to feeling, with the added pressure of, or insistent that we also do some heavier work up front before we would accept a case from a petitioner. So what does a declaration of nullity actually mean? As I've alluded to, if a judge has been able to receive enough testimony from the party and corroborating evidence from other parties, then he might have enough to grant an affirmative decision. And what that means is simply this: that there was a real relationship, that there may even be children, that there may have even been a deep and profound love for one another at one time, but that something was getting in the way, some factor, like those examples that I mentioned earlier, the inability to have true freedom in that moment. Somebody was lying, somebody was deceived, for example. There are many types of grounds along those lines. That somewhere along the line, during that ceremony, the intention or the consent was not really given. So that what we understand marriage to truly be did not fully come into existence. And therefore, because of that, the parties, both of them, not just one, but both, would be considered free to enter into a bond of marriage within the church. One of the things that I hear often when there is a declaration of nullity is that this means that my children are illegitimate. In fact, I just had a gentleman approach me before Mass this past Saturday to talk to me about his brother, who was very upset. His former wife was obtained an annulment from his perspective. She went to these tribunals, she got one, she's married in the church, and now his daughter refuses to go to church because the church thinks I'm illegitimate. That's not the truth. We don't believe that. We never believe that. The child was born out of a seemingly valid marriage that was born out of love and is still a child of God. So children from annulled marriages are not illegitimate. They are legitimate. It doesn't mean, sometimes someone will say to me, does this mean my relationship didn't happen, it was all a lie? No, that's not what it means. It obviously happened. It was real. The two of you together, you were married, you were together for 25 years, or 10 years, or 2 years. There was something real there. Church is not denying that. The church is only looking at that idea of the validity of the marital consent. Does somebody have to get an annulment if they are divorced? No. In fact, there are many divorced Catholics who continue to just live their lives faithfully day in and day out, go to communion on a regular basis, sometimes on a daily basis, but live their lives as if they are still bound to that bond of marriage because they maybe believe it to be valid. They're not interested in pursuing another relationship. And it's very important that when we as Catholics know other Catholics in that situation, that we make sure that they understand that divorce does not mean you're excommunicated. Does not mean you're outside the church. What it means is we want you to come through that door all the more. Because as hard and as difficult as that marital life might have been, you might really find this life as a divorced Catholic even more challenging or challenging in other ways. And we want to help and support you to live out that discipleship. It also might mean that there are times when someone applies for an annulment and is not able to overturn that presumption for various reasons. And what is the role of the church in that position? Again, it's to minister. The person is already remarried outside the church. Well, they may not be able to come forward for communion, but they certainly are invited to come to Mass and to receive the spiritual benefits of going to Mass, of participating in the life of the church. And that the Holy Father's challenge really isn't for the church to start offering more and more annulments. He said that over and over again. He said, it's not about getting annulments, it's about getting a decision in a more just time period, and in a way in which we can help the person journey. But it's also about making sure that we are properly evangelizing families where they are in life and trying to invite them to Christ and include them in the life of the church insofar as we can. It's not about pushing people out the door. One of the things that I think has been an important realization for me working on the tribunal is that I've really seen the work of the tribunal to be two things. One, a real powerful source of evangelization and re-evangelization, and also a place where the Holy Father's vision of the church being a field hospital come to life. And I'll give you some examples about what I mean with that. With evangelization, if a devout Catholic practicing Catholic comes forward for an annulment, wants to pursue the possibility, the whole reason that he or she is there is that the Church is affirming for them the real understanding of the permanency of marriage. I'm here because the Church presumes my marriage is valid, even though I'm divorced, even though the world says it's over, it's ended, it's done, and I should just go out and get remarried again and find somebody else. The Church is saying, hold on, that may not be a reality for you. Let's find out and clarify, and then go from there. So they're confronted with that, and they're reaffirmed of church teaching. If it's a marginally practicing Catholic, they're reintroduced to that reality. And they have the opportunity to think about that again. If it's a non-Catholic, then it's evangelizing and speaking to that reality. So there is a real work of evangelization and pastoral care that takes place. The tribunal is not a cold place. It is if I want it to be. If I want to have that perspective of it, then it's going to be no matter what. That's also been my experience. No matter how kind or compassionate or listening we are, if somebody decides that Father Workman is just a cold jerk, I don't know how to overcome that if that's what they want. But my experience is that there's a real pastoral dimension to all of this. The field hospital is a perfect example. There are a number of times where someone has said something like this. This is the first time I've ever said this to a priest. Catholics, lifelong Catholics. I've never told a priest this. It might not be about their marriage. It might be about their family background. It might be about another difficulty. And we're able to start connecting them to counseling that maybe they've always wanted, always longed for, but maybe there was something holding them back, or they didn't know exactly where to go or who to trust. And there have been a number of times. One time I had somebody who was very upset that she was non-Catholic and their husband was pursuing an annulment, and she was worried that things were being distorted, so she participated, and she was very upset that there was an affirmative decision. I just said to her, go read before you do anything, go read the sentence. She came and read the sentence, and she looked at it and said, wow, you got it dead right. Another gentleman said to me one time when he just came in, he just wasn't fighting it, but he was a respondent. He came in, wanted to read all the testimony. Everything that his former spouse had put in, the witnesses, and he spent a long time reading through it carefully. And as he was leaving and he was signing some of the papers of confidentiality and everything, he turned to me and he had tears in his eyes. And he said, you know, Father, I'm not perfect. I've never been perfect. He said, but there's so much I understand and see more clearly now than I did back then. And there were things that were going on in the background I never knew until this day. And now I understand what was going on. That's the field hospital aspect of what takes place. So the tribunal is there to help journey. It's there for justice, it's there for truth, it's there for charity. And it's all of those things coming together, simply asking the question, what is the truth about the status of these parties? And allowing both parties to bring their perspectives and their understanding of the truth before the Lord, so that if they are free to enter into a new bond of marriage, they may. I know that this has probably brought a lot of questions, so I want to leave ample time for Q&A here this evening. Are you asking if we're going to continue doing what we're doing and then slowly implement, or are you asking if there will be a two-track system once it starts?
Is it the existing procedure going to stay?
Okay, yeah, so by and large, what will happen on December 8th, what's supposed to happen, is that there will be the possibility of a two-track system. The first track is the one that we're by and large already using. The petitioner applies, they give testimony, they have witness testimony, they might see an assessor, the respondent participates, doesn't participate. It goes through, once we have everything, then it goes to the defender of the bond, who sort of reviews and makes observations known to the judge about whether rights are respected. Is it a weak case? It is a strong case. And then it goes to the judge's list. And then when it gets to the top, he writes a sentence. I mean, right now we have over 250 cases that are just open in our tribunal. So sometimes when people are saying, why is it taking so long? It's because, well, when you got in line, it's like getting in line at the DMV. You got in line back here, and this one, and then this one, and you slowly get up to the top. So that process will, by and large, be the normal, what's called the ordinary process. The abbreviated process might also be a possibility in some rare instances. And those instances would include when, in the Pope's words, it is manifestly null. Manifestly null. We're not exactly sure, primarily or canonically, what manifestly null is, and that's because we start with the presumption that there's no such thing as manifestly null. We start with the presumption that every marriage is valid, right? So we're bringing in a whole new canonical category of manifestly null. That's not just the documentary cases, a Catholic got married outside the church and never got married in the church, right? We're talking about something different. Two Catholics got married in the church, but somehow it's manifestly null. Well, we understand a little bit about what he means. It could be because there are other corroborating documents right up front that both parties can bring and agree to. So things like police reports, serious things. Police reports, medical exams, maybe psychological exams, something that they're both bringing forward and saying, yes, this is what was going on. And what the judicial vicar can look at that and maybe with a little bit of witness insight say, we don't need to do an in-depth thing. We almost have enough right here. And so what that process would be lightly, and I'm a little bit hesitant to go too deeply into this just because there's a lot that's being discussed and unknown, and we don't have a full perspective of how we're going to absolutely implement this in the Diocese of Arlington yet. We're trying to talk with other dioceses in the province. And also the USCCB has some work to do on all of this. But in a general sense, then what's supposed to happen is the full petition is written, the judicial vicar sets the grounds for the case, and then gives it to a person who's called an investigator. And the investigator then would take over and has a limited amount of time to basically get all of the little extra things together that would not be extraneous. And then it's all presented to the diocesan bishop with a recommendation and two assessors who evaluate and let the diocesan bishop understand what's going on. And then the diocesan bishop has a number of days to make a decision. And he has two options. He can either say, yes, this was manifestly null, and I see it now, it's very clear. Or he can say, no, I'm not there. So I'm going to put this back to the ordinary process. So we go back to the ordinary process and go through the full system. But I think those will be rare instances simply because, as I said, both parties would have to agree. And if you're talking about these extreme manifestly null things, you're probably talking about some very serious stuff. And if it's one party coming forward blaming the other of those serious stuff, the other party's probably not going to be anxious to agree to that. So I don't know how often those abbreviated processes would come forward. More than likely, it would be the person who's primarily responsible bringing that forward, saying, hey, I didn't know it, but I had this grave psychological thing going on. Here's the report. And the other person saying, yeah, that's exactly what happened. And that might be enough that we would be able to take that route. We're very careful about how we gather the information because it is a highly confidential process. One of the things that we try to do, and the church encourages us to do, is to talk to parties directly. So when we get testimony from the petitioner and the respondent, we actually like to sit down face to face and talk with them, record the conversation, have it all typed up. Witnesses, what we like to do is give the questionnaire to the party. So if you were petitioning, for example, I'm not saying you are, but if we would give it to you and say, please hand these to your witnesses. And the reason we do that is because we found that if the party gives the questionnaires to their witnesses who know and love them, they're much more responsive to that than if it just comes from Father Workman in the office of tribunal, right? They don't know me, probably, and they certainly don't care about me, probably. And so, but they do know and care about the parties. So when they give them to them and say, would you please be willing to fill this out, then they're much more apt to complete it. The other possibility that we do is collect phone testimony, where we call and verify the party and take a deposition by phone. And sometimes, on rare instances when it's been requested, we do what's called a rogatorial, which means that we have let's say a case is being heard in the Diocese of New York, but the witness or the other party lives here. They ask us if that party can come into us, and we would ask questions that they send to us, record it, and send them the typed transcript. Basically, what any sort of, what we call that, I put it in terms of not basically telling the whole truth. What we call that is a simulation. Somebody's simulating their consent. And for somebody to simulate that, they have to be able to say, like, generally or very, very clearly, in their mind, it has to be a positive act of the will. So it has to be, I really don't want or intend ever to have children. Or I intend to not have children until XYZ. Not if it's a, well, maybe if I can, I really like to, well, then we're not getting at that level of simulation at that point.
So it needs to be, I never intended.
Never intended, or we're not having children until we are married 5 years, and we never get to that 5 years. Or I'm intending not to have children until we're financially stable, and we never get to financial stability. Our marriage breaks down before that. So we never get to the point where my consent has opened up to children. Does that make sense?
Yeah, and just a follow-up.
It can be harder for the petitioner if the witnesses are not strong. So that's something that sometimes we encounter. One of the things we try to do in situations where, let's say the marriage was 30 or 40 years ago, and someone's just coming forward now. And they might say, well, the people who really were my best witnesses are people I know, but the people who are my best witnesses who can really corroborate what I'm bringing here, they're deceased. And so I don't know what to do. Well, usually what we do in that point is say, okay, why don't you go and the former spouse refuses to participate. What we usually say is go and get some witnesses who at least knew you, and let's see what they know. They might know more than you think. And then from there, we might go into character witnesses. Let's get some people who've known you for a long, long, long time, how they know you, and can speak to the type of character and your character and your honesty, and see where this goes from there.
But what if you got a situation where it's just the petitioner and what was going on in his head at the time, that, he's doing this for some other reason other than what would be a valid marriage, and he's the only one that can speak?
Well, we'll always first start in that simulation type of thing. We always start with what we call a confession. The party who did it has to confess it somehow. So if the petitioner comes forward and says, you know what, I got married for the green card. I didn't really intend to get married. In fact, when we got married, we kind of had a plan of when this thing would end and we would get divorced. And that's sadly a reality. But so that person has to bring that forward. And then we look at other circumstantial evidence to help support that. So we always have to start with that first, what the person is bringing. If it's more of a psychological issue where there's maybe some sort of pressure or other psychological factors that could have been temporary or permanent, well, we also always include a psychological expert as part of our evaluation. So the person has to go and talk to one of our court-appointed assessors that helps us understand the validity of these internal factors that might be beyond that are, in fact, beyond the competency of the ecclesiastical judge.
So would the tribunal ever come up and say, we just don't have enough information
Yeah.
for determination, and therefore it's valid?
Well, what we would do is one of two things. The first thing we do is to contact the party and let them know. All right, we're struggling here. This is where we are. So let's talk about some things. What we'll try to do is try to help you make the best case you can to protect your rights. And then at that point, if we can't find anything, we'll say is, we don't have enough to proceed. We recommend withdrawing your case. And the reason why is that 5 years from now, if new evidence comes to light, we can hear the case on the same grounds again. Because we always try to set the grounds on the best grounds that we think might be the most provable. Because we don't want to waste anybody's time. We don't want to waste our time, we don't want to waste your time, the respondent's time, witness's time. So we want to try to do the strongest grounds that we think might be possible. And so we'll ask and say, you might want to consider twice. Sometimes petitioners will say, no, I want to go through. And then we're forced to give a negative decision at that point, because we don't have enough to overturn that presumption. And then the petitioner has options of appealing, like I said, even right to Rome. If we truly can't locate them, we name them unlocatable. We have an ability to do that. And then we appoint them what's called a procurator advocate, who protects their rights and looks out. One of the things we try to make sure that we're never doing is rubber stamping things. So the role of the defender of the bond becomes much more important, and also the role of the procurator advocate to act on their behalf, to make sure they review everything that's happening, question everything, write a brief if they want to, point out things to the judge if they want to. So that's what we do. We won't let that uphold moving forward for a petitioner.
And whose responsibility is to find them?
Primarily, it's the petitioner. We ask them, because this is what sometimes happens. They'll say, I can't locate him or her. And then we find out, well, if they knew exactly where they were. They dropped the kids off there every other week. They just didn't want to give the address. So it's one way to make sure that we really get the right address. But if they honestly can't, then we will try. But if we can't, then we'll try all kinds of avenues. We'll eventually have to get to the point where we say they're unlocatable. And then that's when we appoint the procurator advocate and move forward. The Year of Mercy. Well, I think one of the things that Pope Francis is trying to highlight in the Year of Mercy is not so much, I think what he's trying to do is this. We think of the annulment process primarily what our experience is here in the United States. We can also look to other first world countries in Europe and other English-speaking countries. One of the presenters at our Canon Law Conference, the same priest that was on the council, said that the first thing that they did was look at the rest of the world outside the English-speaking countries and Europe. And they realized that there were only 16 established tribunals outside of that. And of those, only about half of them were functional. So what the Holy Father's trying to do is reach out to those areas. You know, he's always talking about the poor. It's very difficult, and one of the reasons why our cases get hung up in Latin America, in other countries outside the United States, is because those tribunals don't have, or those dioceses don't have enough money to have the personnel in their tribunals. They don't have the money to properly train their priests to work on their tribunals. And so even with the simplest matters, they kind of freeze up. Also, in certain countries, unfortunately, for someone to move a case forward, they got to hire an advocate, which can cost thousands of dollars to get in there and basically tell the judge what they're supposed to do. So the Holy Father in the Year of Mercy is looking at saying that's not just. It's not fair that wealthy countries have these opportunities in their dioceses and the poor do not. So his hope is that by emphasizing this change in the law and the prominence of the Year of Mercy, that in one way, those poor countries will have greater access to a process, not a decision of in favor or not in favor of nullity, but just a decision that clarifies their status. And then also, I think along with that, is got to be an emphasis towards pastoral ministry to the divorced and to the divorced and remarried in the church, to make sure that we're reaching out and we're trying to support people in those situations. Each diocese is going to be a little bit different. There's a cost and then there's a fee. Okay, so the cost of our tribunal, I don't know, I'm not going to give a number because I don't know it precisely. I do know that we have 4 full-time lay staff members. We have 2 full-time priests. We have a part-time judicial vicar. We have a number of psychological assessors. And so the fee that we ask for is neither mandatory, it can be paid over a period of time, and somebody can have it waived or reduced for financial reasons. The standard offering we ask for is $750. That's a fraction of what it actually costs us to process each case. And so the reason why we do that is because we wouldn't be able to function we wouldn't be able to move cases without that. We're subsidized by the diocese and then by that fee. The Holy Father has asked that where possible, we could reduce the fee and not make it available. The difficulty is it's never going to be a free process. It's always going to cost something. The difficulty is if we reduce the fee or get rid of it, we have to figure out where that's going to come from. And what the idea of the Holy See is that goes back to the parishes, so parishes have to pay more. And so we're like, okay, well, is that the way we want to do things too? Is that fair? So we're trying to figure that out too.
So that's the fee and a cost.
Yeah. It doesn't go to the person. The fee would be paid by the petitioner. But the cost goes to the whole tribunal budget. Yeah. Usually more is better. And part of that is that we're looking for substance. So in more legalese terms, we're trying to build, we're looking for what are called juridic facts. Juridic facts, so legal facts. So if somebody comes forward and the petitioner or respondent makes a statement regarding the validity or invalidity of the marriage, then what we're going to say is, okay, here's a piece, here's a piece, here's a piece. And Rome is pretty clear about giving us a reasoning and an legal understanding behind each ground. So it's not just simply a subjective thing. There has to be certain criteria that are met to reach that level of moral certitude. And so when we set a ground, we know, okay, this has to be proven, this has to be proven, this has to be proven. And if these 3 things are proven, then we get moral certitude. And so what we look for are a collection of corroborated facts that prove that checklist. So what we would do is, so that's why more is often usually better. When we tell parishioners or petitioners, when they go back to their witnesses with that list of questions, we say, please don't answer them just yes or no. That doesn't help. You're not going to know every answer to every question, but what you do know, please amplify. Add to it. Tell us as much as you can about that. And then what we ask for at the end is their contact phone number, so that if we think there's even more there, we think it's going to be even more helpful, we can follow up with phone testimony.